Ma'am, it's very important that you be quiet. I'm trying to explain something very important to this gentleman, and it is very distracting when you're talking in a normal voice in my courtroom. If you cannot control yourself, please leave, because this gentleman has the right to understand what I'm going over with him. Do you understand me?
I do.
That's very rude.
I can do it.
This is case number 26CR43631, the State of Ohio versus Andrew Pasco. Mr. Pasco is before the court with his counsel, Mr. McMullen. Ms. Tranter, on behalf of the State of Ohio. Ms. Tranter, what are we doing?
Your Honor, my understanding is that Mr. Pasco is prepared to change his plea as charged to the indictment. Count 1 is a felonious assault, felony of the 2nd degree. Count 2 would be domestic violence, felony of the 4th degree. My understanding is defense is going to be asking for a pre-sentence investigation and asking to set the matter over for sentencing.
All right, Mr. McMullen, is that accurate?
That is accurate, Your Honor.
All right, Mr. Pasco, they're telling me that you're going to change your plea to guilty to the 2 charges, 2 counts of the indictment. Before I get to your change of plea, I am required to go over some things with you, okay, sir?
Okay.
How old are you?
43.
How far did you go in school?
I've got my GED, and then I've got 2 years accounting degree.
All right, so are you able to read and write okay?
Yes.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you in this case?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation that you received from Mr. McMullen?
Yes.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take any medications that interfere with your ability to understand what's going on today?
No.
I have in front of me a document called a change of plea. On page 3 of this document, on the line that's marked defendant, there appears a signature. Did you sign this?
Yes.
Did you read this and go over it with your attorney?
Yes.
And you feel like you understand what it says?
Yes.
This document says you're pleading guilty to 1 count of felonious assault, a felony of the 2nd degree. That is what we call a Reagan-Tokes charge. So that carries a maximum penalty of a minimum term of 8 years in prison, and a maximum term of 12 years in prison, and a maximum fine of $15,000. That prison term is not mandatory, but presumed to be necessary. The 2nd charge is one of domestic violence with a prior conviction. A felony of the 4th degree, that carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. That prison term is not mandatory either. Do you understand those maximum penalties?
Yes.
Do you also understand that you're pleading guilty to 1 offense that requires the court to impose what's called an indefinite sentence?
Okay.
Okay? So, with regard to the felony of the 2nd degree, that I said that carries a maximum penalty, minimum term of 8 years, but there's a range of penalties there, okay? So the court will select a number for that offense somewhere between 2 and 8 years in prison if I'm going to send you to prison. Do you understand that?
Yes, sir.
All right. And then the other offense, because it's a felony of the 4th degree, carries a maximum penalty of 18 months in prison. That does not carry an indefinite sentence. Do you understand that?
Yes.
So if you're sentenced to prison, you're going to receive both a minimum term on that offense and a maximum term on the felony of the 2nd degree, okay?
Okay.
The court will select a number for the minimum term between 2 and 8, okay?
Okay.
That will be your minimum term sentence, okay?
Okay.
The maximum term is automatically calculated to be that number plus 1/2 of that number, okay?
Okay.
And then the court will also select the number if I say, again, this is all based on if I send you to prison. So I'm going to be giving you the worst case scenario, the maximum penalties, okay?
Okay.
Just so you understand. So the court will select the number between 2 and 8 for the minimum term on that offense, and the maximum terms are going to be automatically calculated to be that number plus 1/2 that number. So the maximum penalty on that offense would be minimum term of 8 years, maximum term of 12 years, okay? On the 2nd offense, the 18 months of the domestic violence, are those going to merge? We have one.
Judge, I believe that they will merge. There's
Okay.
1 victim.
So I'm going to tell you right now that because there's only 1 victim, the domestic violence and the felonious assault are what we call allied offenses of similar import, okay? So they're gonna merge together for sentencing, so you're only gonna receive one sentence on the, and I'm guessing, again, I'm kinda guessing here, but usually, once I've merged those two offenses together, ma'am, it's very important that you be quiet. I'm trying to explain something very important to this gentleman, and it is very distracting when you're talking in a normal voice in my courtroom. If you cannot control yourself, please leave, because this gentleman has the right to understand what I'm going over with him. Do you understand me?
I do.
That's very rude.
Sorry.
All right, Mr. Pasco, I apologize, because I want to make sure that you understand completely everything that we're talking about here. So we were talking about merger. These two offenses are going to merge together into one sentence, okay? So you won't be sentenced on both charges. The state gets to elect or choose which of the offenses that I sentence you on. And I'm going to guess that they're going to choose count 1 because it's a more serious offense, okay? So you'll receive both a minimum term and a maximum term sentence. The highest minimum term would be 8 years, and that would mean that the highest maximum term would be 12. Okay? We good?
Good.
So the longest minimum term you could serve is 8 years. The longest maximum term is 12 years. There is a rebuttable presumption of you being released after you serve the minimum term or a presumptive early release date, whichever is earlier. The Department of Corrections may rebut that presumption through an administrative hearing process and thereby maintain your incarceration for reasonable periods of duration up to the maximum term of 12 years. The criteria for the Department of Corrections to rebut the presumption and to maintain your incarceration after you serve the minimum term or presumptive early release date, whichever is earlier, include the following. Number 1, during incarceration, you commit a rule infraction that compromise the prison's security, you compromise the safety of staff or inmates, you cause or threaten physical harm to staff or inmates, or you commit a violation of law that was not prosecuted, and any infractions or violations which demonstrate you have not been rehabilitated and or your behavior demonstrates you continue to pose a threat to society. Number 2, regardless of your classified security level at the time of the hearing, you had been placed in extended restrictive housing within the year preceding the hearing date. Number 3, at the time of the hearing, you are classified by the Department of Corrections as a security level 3, 4, 5, or higher. If the Department of Corrections rebuts the presumption, the Department of Corrections may maintain your incarceration in a state correctional institution under the sentence after the expiration of the minimum prison term or presumptive early release date for a reasonable period of incarceration to be determined by the Department of Corrections, not to exceed the maximum prison term. The Department of Corrections may maintain your incarceration more than one time up to the maximum term. The Department of Corrections shall release you at the expiration of the maximum term if you've not already been released. You are eligible to receive 5% to 15% earned reduction of minimum prison term credit for exceptional conduct or adjustment to incarceration, but there is no guarantee that the Department of Corrections would request ERMPT for you. There is a presumption that the ERMPT will be granted by the trial court, but the trial court may determine to rebut the presumption and not grant the ERMPT. Do you have any questions about those instructions?
Yes, sir.
Okay, very good. Now, you are presumed innocent in this case, which means you cannot be sentenced or punished in any way unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, you have the right to confront and cross-examine each of the prosecutor's witnesses. Do you understand that?
Yes.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes.
The standard of proof is beyond a reason your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes.
Do you believe you understand each of these rights we've discussed?
Yes.
Do you understand that when you enter a plea of guilty, you will be waiving all these rights? We will not have a trial.
Yes.
Do you understand that a plea of guilty is a complete admission of your guilt, and the court could proceed directly with judgment and sentence?
Yes.
This is how you wish to proceed today?
Yes.
All right, Ms. Tranter?
Your Honor, in addition to the facts alleged in the indictment, this incident occurred on or about May 8th of 2026, Warren County, state of Ohio. On that date, Your Honor, Mr. Pasco was living with his girlfriend, Linda Ballard. Police received 911 calls from the victim and the defendant, actually stating that he had struck her. When they arrived, she was bleeding from the face. Further investigation found that he had assaulted her, presumably with an alcohol bottle that they had been drinking. Victim had lacerations on her face. It required multiple stitches. She ended up being diagnosed with an orbital fracture and a cheekbone fracture at the hospital. She is still undergoing surgical consults and will end up having to have multiple surgeries to be determined at a later date, causing her serious physical harm.
Mr. McMullen, anything on those facts? Hey, Jonathan, you need to hit that mute button or move over away from the microphone.
Okay.
That's being broadcast out.
All right, I'm sorry, Your Honor.
Your Honor, the only issue we take with the facts is that we believe this was only with hands. There was no potential weapons involved, Your Honor. Other than that, there's no dispute on the facts.
Okay. Was there a weapon involved?
Judge, there was not a traditional weapon involved. The incident, I don't think it is disputed that the parties were drinking alcohol from what is called a buzz ball. So it's like literally a ball-shaped container. The victim believes that while he did hit with hands, that instrument may have been used as well because of the severity of her injuries. So that would be...
Okay, I don't want to get into the weeds on this because, you know, quite frankly, Mr. Pasco, whether there was a weapon used, now if you use a felonious assault can come in two different ways. Number one, you can use a deadly weapon to cause or attempt to cause physical harm with a deadly weapon, or you can cause serious physical harm to someone. So I guess the state is alleging that you caused serious physical harm to her. Whether there's a weapon involved or not really doesn't come into play. So do you admit the truth of those facts as stated?
Yes.
All right. And again, you understand all the rights you're giving up when you enter plea of guilty, those rights we went over.
Yes.
What is your plea?
Guilty.
All right. The court's going to make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights, and the court will accept your plea of guilty. And based upon the statement of facts in your plea, the court will make a finding of guilty. Mr. Pasco, I don't know enough about you to sentence you today, so I am going to order a pre-sentence investigation, and we'll come back in a few weeks and do sentencing at that time. Okay, sir?
Okay.
All right. Thank you, sir.
Thank you.
Yeah.